Imagine you're scrolling through social media and you come across another business using a name that looks almost identical to yours. It's the same industry, the same target audience, and they're out there marketing, building a following, maybe even ranking in search results. Your first reaction is probably some version of, can they do that? And what can I do about it? Today, I want to answer both of those questions. If you have a registered trademark and somebody else is using a confusingly similar name or mark, you have real options. And knowing what those options are and how to use them strategically makes a big difference in how this plays out. Before we get into your options, it helps to understand what trademark infringement actually means, because it's not just about an exact copy. The legal standard is likelihood of confusion. That means if another business is using a name or mark that is similar enough to yours that consumers might confuse the two, who they're buying from, who's affiliated with whom, that can constitute infringement, even if the mark isn't exactly identical. Courts look at a number of factors: how similar the marks are, how similar the goods or services are, how strong your mark is, and whether there's any evidence of actual consumer confusion. The key point is that you don't have to prove somebody deliberately copied you. Infringement doesn't require intent. If the result is consumer confusion, that's what matters. The first thing I tell clients when they come to me with a potential infringement situation is to slow down before we react. Before we take any action, we want to actually assess what we're dealing with. Is this a business in the same industry or a completely different one? Are they operating in the same geographic market? Is there genuine consumer confusion happening or just a superficial resemblance? You also want to look at their registration status. Have they filed a trademark of their own? When did they start using their mark? Priority, meaning who used the mark first in commerce, matters a lot in trademark law, and you want to understand the full picture before you react. This assessment shapes your strategy. A business that's unknowingly using a similar mark in a completely different industry is a very different situation from a direct competitor who appears to be deliberately riding your coattails. In most cases, the first formal step is a cease-and-desist letter. A cease-and-desist is a written demand sent by your company or your company's attorney that puts the other party on notice that they are infringing on your trademark and that they need to stop. It typically identifies your registered mark, explains how their use creates a likelihood of confusion, and gives them a deadline to respond or comply. You might be surprised how often this actually works. A lot of trademark infringement situations resolve at this stage, especially when the other party generally did not know that your mark existed, or they'd rather rebrand than face a lawsuit. The cease and desist also serves another important function. It creates a legal record. If the other party ignores it, and you do end up in litigation, the letter demonstrates that they had actual notice and chose to continue infringing. And that can be very relevant to you getting damages later on. Sometimes a cease and desist opens a conversation rather than closing one. The other party responds, they have questions, or they want to negotiate. That's not necessarily a bad thing. A negotiated resolution can actually be faster, cheaper, and more certain than going to court, and it gives both parties more control over the outcome. In some cases, a coexistence agreement makes sense, where both parties agree to use their marks in a way that minimize confusion, often in different geographic markets or product categories. The goal here isn't to win in the adversarial sense. It's to protect your brand, stop the confusion, and move on. A settlement that accomplishes that is a good outcome. Here's one that a lot of business owners don't know about. If the infringing party has filed or is in the process of filing their own trademark application, you have the ability to challenge that through the USPTO. If their application is still pending and within a specific window, you can file an opposition, essentially a formal objection that says, this mark conflicts with mine and shouldn't be registered. If they've already been granted a registration, you can file a cancellation proceeding to have that registration removed from the registry. These proceedings happen before the Trademark Trial and Appeal Board, the TTAB, which is part of the USPTO. It's a more formal process than sending a cease and desist, but it's less expensive and less time-consuming than federal court litigation. If a cease and desist is ignored, negotiations break down, and the infringement is ongoing, federal litigation is on the table. Trademark infringement cases are heard in federal court. As a registered trademark holder, you have the right to file suit and seek remedies that include an injunction, which is a court order requiring the other party to stop using the mark, as well as monetary damages. If the infringement is found to be willful, meaning the other party knew about your mark and continued anyways, courts can award enhanced damages and attorney's fees. That's a significant exposure for the infringing party, and it's often what brings people back to the settlement table even after earlier negotiations stalled. Litigation is expensive, and it takes time. I'm not going to pretend otherwise. But it's also the backstop that makes all the earlier steps credible. When the other party knows that you're willing to go to court, the cease and desist carries a lot more weight. I want to leave you with one thing that often gets overlooked. Once you have a registered trademark, you have the responsibility to monitor it. The USPTO won't police your mark for you. If someone starts using a confusingly similar name, it's on you to catch it and take action. Consistently failing to enforce your trademark can actually weaken your rights over time. That means watching for new trademark applications that might conflict with yours, keeping an eye on the industry, and taking infringement seriously when you see it, even at the early stages. The earlier you act, the more options you have, and the lower the cost of resolution. If you've discovered that somebody is using a name or mark that looks a lot like yours, don't wait. The longer an infringing use goes on, the more complicated it gets to unwind. At Business Law Group, we help trademark holders assess their situation, determine the right strategy, and take action, whether that's a cease and desist, a negotiated resolution, or something more formal. You can book a consultation directly on our website. We'll take a look at what you're dealing with and help you figure out the best path forward.